Hello, welcome to Legalese. My name's Christopher Lilly, I'm your host. Legalese is a presentation of the Northern Middlesex Bar Association. Today we are joined by Christopher J. Reardon, attorney at law, who is also the president of the Northern Middlesex Bar Association. Chris, welcome.
Thanks for having me, Chris.
No, thanks for being here. Today's topic is going to be criminal restitution. Now, restitution brings up the idea of remedies. Remedies that someone may receive as a result of economic losses that they may have received through the course of criminal conduct committed by another. But there are also civil remedies that are available to people in the district court and in other civil courts, superior court. Civil remedies that are available. Typically, you might see it in district court in the form of a small claims action, or just a complaint, a civil complaint. What we're dealing with here, however, is restitution as it comes up from a criminal case. And there's one case that I wanted to start with. If I could, Chris, just talking about, this is a case that I was familiar with when it had first come out back in 2001, Victory versus the Air District Court, where Judge Kilmartin, I think it was at the time, had denied a number of petitions of the Victory Supermarket at the time, where they brought about 20 requests for criminal process to issue, which goes through a clerk magistrate's hearing. They had brought those requests based on charges of larceny by check. So basically, bounced checks had been brought to the Air District Court seeking criminal process. I think it was Judge Kilmartin, but it was the judge that had determined at that point, no, we're not going to issue those. We're not even going to have a clerk magistrate's hearing, because we don't have the judicial resources to allow that to occur. He also had indicated, I think in some of the comments, that not to use criminal processes as a means of collecting civilly, and he referred them to the small claims court. This kind of brings into mind the difference between criminal and civil collection for your losses. Now, the criminal court does have the ability to collect for an alleged victim for their economic losses. And Chris, you've dealt with a number of those types of cases.
Yeah, and usually in the cases you described, it's a case of theft or a case of some type of stealing. Mm-hmm. At some point, there's either a trial where there's a guilty or a plea there, prior to that. At some point, the judge is going to order restitution. And as you said, restitution is money that they pay through the court system that will eventually get to the victim to make them whole again. Mm-hmm. That's the idea of the restitution. What was happening was in a case where, in this Commonwealth v. Henry is a good example of it, and that's a case that recently came down from the SJC that we've been relying on over in the court. Mm-hmm. But what was happening, restitution was being ordered up front. There was some type of hearing that would say that, this amount of money was owed back to the victims to make them whole. The person or the defendant would agree to that restitution, be put on probation for a period. Usually, and then in this case, I think it was 18 months. The girl, her name was Kim Henry. Mm-hmm. She was put on probation for 18 months, and she was ordered to pay about $5,000 in restitution, and that money was to go back to Walmart. How this all happened was Miss Henry was a cashier for Walmart, and she was doing what was called free bagging, meaning she had friends come in and she'd run the items over the scanning.
Those are the allegations.
Yeah, and what she would do is not really register them in. Mm-hmm. Through some of the video surveillance, they caught Miss Henry, and she was charged. Now, again, she was ordered to pay $5,000 restitution. About a month after the hearing, she went back to court and said, look, I can't pay. And in fact, she'd only made about two $5 payments on the $5,000. And at that time, the court extended her probation. I think that was the biggest problem in the whole case, was they were extending her probation just to pay this restitution, which was never going to be paid. And that's the government taking your liberty in some form, and the courts found that that was a real problem.
So I want to break down the Henry case to a great extent. That's the case that just came out and has kind of changed the way that things have been approached in ordering restitution and how that plays with probation. But first, let's break it down a little bit. Probation, is that a necessary component to restitution?
It's the only way to make them pay.
It's the only way you can enforce it, right?
Exactly. And this court, along with what you said, left open the civil remedy. There's always a civil remedy, but there's statute of limitations to those civil remedies. Sure. And I think that's where some of these get caught up, is somebody's ordered restitution, they let the statute run civilly, and they're really relying on the criminal court to enforce that. The court can enforce it by putting them in jail, though, if you don't, because that's a condition of probation. Mm-hmm. And if you don't do every condition of probation, the court can at that point sentence you to the maximum of whatever charge you're on probation for.
Okay, so a person now is sentenced to probation. As part of that, the court determines that some restitution needs to be ordered, whether that be the full amount or that be some other amount or what that amount should be. That gets determined at a restitution hearing, correct?
Correct.
What happens at the restitution hearing?
Depends on what witnesses are brought in, what documentation is brought in. Now, I think a lot of these cases where the victim was a big enterprise or a big store, the courts looked at that and they said, the store themselves really have to, by a preponderance of the evidence, prove their economic loss, whether it be retail value or some other value. That's on the actual victim themselves to come to these restitution hearings and put that information before the judge. The other thing the judges are looking for at a restitution hearing, and what this case dealt with specifically, was the defendant's ability to pay the restitution. Okay. And on that side, it's the defendant's burden to show that they either can pay a small amount, they can pay a full amount, or they can only make monthly payments, and that's their burden.
Prior to the Henry case coming down, did you see much focus in these hearings on a defendant's ability to pay?
No. And a lot of that is because when these happen, the defendant is there pleading the case. Mm-hmm. A lot of these charges are very serious charges. The money with the restitution that we're talking about usually comes from forgery, uttering, larceny over $250, which are all felony charges. Mm-hmm. Where we stand in the district court, these people are lucky that they haven't been indicted to go up to superior court. So,
or they may be cutting a deal that would be non-criminal.
And I think that that's where they don't fight for the restitution. I think we as attorneys have to separate what they did, what the penalty should be, and if they're not getting jail, we really have to look at the restitution to make sure it's going to get paid. We don't want to set them up to fail. That's the first thing we learned as lawyers doing criminals. We can't set either side up to fail.
And the idea of setting somebody up to fail, I think, was something that was hammered home by the court in the Henry case. We don't want to be setting people up to fail. Let's go into it a little bit. The idea of setting somebody up to fail with a restitution amount, how does that play out in the Henry case?
In the Henry case, they never had a hearing on the defendant's ability to pay. Mm-hmm. And what they did, and I believe she stipulated, if I read the case correctly, there was a restitution hearing about a month after she had taken the plea. They came in and they stipulated, which basically means Walmart, as the victim, had said, look, we are out, and they did go on the retail value in this case. They said, look, we're out $5,200 and some change. Miss Henry stipulated to that amount, which means she didn't have a full restitution hearing. She agreed to that number. Now, what happened a month, I believe it was about a month later, she filed a revise and revoke, which basically is a motion that you ask the court to revise or revoke the order they just put in. The court did not do that, and at that point, that's why she still owed the $5,000, and they extended the probation.
She wasn't able to pay it.
She wasn't able to pay. I think what the case said, some of the footnotes, she'd only made 2 payments of $5 over the time she had supposed to pay about, $5,000 or, a 16th of that.
So now the whole point, and this is something else that was referenced in the Henry case, was the whole point of restitution. The whole point of probation is to try to rehabilitate somebody. But when you have a violation of probation, you don't want to punish someone again for the same conduct. You don't want to have them punished, as I said, for the same conduct as far as what has happened before. So a violation of probation deals with the idea that that
it could be anything. Basically, you're not doing something the court has ordered you to do. And when they're put on probation, they're signing a contract. And part of that contract says you will pay $65 a month probation supervision fee. You will pay a $50 victim witness fee. They can also put in there you can pay X amount restitution, and there's a form that goes along with that, but either in whole or monthly. Courts are even good enough, and most judges are good enough to do that. If a restitution order is put in, they'll actually waive the $65 a month probation supervision fee while they're paying restitution. So if somebody owed $1,000 in restitution and it took them about a full year to pay that off, they're going to save about $780 in probation supervision fee.
Sure.
But they have to pay that restitution. And the violation of probation comes when they just either can't make a payment for a month. And where we usually see it is somebody tried to do it, then they didn't make one on the second month. They didn't make it on the third month, and the probation department doesn't have time to call and check up on it. They're just checking the file and saying this payment's not in.
Right.
Why don't we send them a notice to come stand before the court, and the judge can ask them where the money is.
And that's a probation violation proceeding.
Usually, if they give them formal notice, but that's where they'll end up before the judge. And that's, probation's doing their job, but the judge wants to know, why aren't you following the order that I told you to do? They don't tell you to do a lot, but what they tell you to do, you have to do.
And there are other forms of probation violations, such as committing a new offense. And you see people who may have a new arrest or something. Now they have a violation of probation that comes with them, because one of those orders is not to commit any new offenses. So the idea behind a probation violation hearing is that you want to, or probation violation, is that you're punishing that person for a willful violation of your orders of probation, correct?
Correct, and it's very rare.
And that's how it's different, I think, from a failure to pay restitution in many cases, right?
And the court brought that out in this case, saying it's very rare that we would ever see somebody willful not paying the money. But in fact, that was the allegation A case that I had that came in on both sides of this decision. To bring it forward, a client that I had a prior hearing where they made the determination that she just couldn't pay about $30,000 that she owed, and the probation had been extended already. I came into the case, and while it was pending, Commonwealth v. Henry came down the night before we went back to court. We had a couple more hearings because it was impossible to decipher this, or the judges weren't ready to decipher this the day after it came down, because what the case basically said was, no, you cannot extend probation just because there's outstanding restitution. That judges have to do a determination on the ability to pay, and if somebody can't pay, they have to basically agree with that. And that was so hard with the case I had, was the judge had to look at the victim in the face and say, I'm sorry, but the SJC just said that, no, she does not have to pay you. And I don't think the judge was comfortable doing that, but she did state, now that is the law I have to follow.
So the Supreme Judicial Court, in making this decision, focused on a number of things as far as what some of the remedies might be, as far as being able to collect from this individual. And the idea of extending probation they found to be too much to ask for. Why?
Because when they extend probation, understand when you're on probation, let's say it was, forgery or uttering, larceny. All those carry up to 2.5 in the House of Correction. Now, the normal deal that you will get, or an average deal would be, a continuance without a finding, or even a guilty, and just straight probation, say 18 months, pay the money back. What happens is, if there's a violation of non-payment, you can still get that 2.5 in the House. Now, a lot of times, it's not just forgery, but it's uttering and larceny together that are all, so you have 3 charges that are there, technically being supervised on probation. A judge could give a person 2.5, 2.5, and 2.5. Very unlikely, but can happen on the circumstance. And I think the compelling cases you see where a lot of the judges have a lot of struggle with this is like somebody that's providing or caring for an elderly person then takes advantage of them, steals their money, steals their heirlooms, sells them for short money, and we're talking $50,000, $60,000, $70,000 in lost property. Before this case came out, it wasn't uncommon for somebody to be ordered to pay $70,000. Now, one, they were just found indigent and couldn't even afford to pay full price for an attorney. They're never going to pay that $70,000, and that's setting them up to fail. That should have never been done, because on that day you can see that at some point that person is going to do up to 2.5 in the House, because they'll never pay that money, never.
And I think the court was also focusing on the additional punishment angle, where if you extend a person's probation, you're punishing them further.
Absolutely.
And you're exposed, as you said, to those types of fallout. But even something as simple as you got to go to a probation officer every week or month or whatever's required of you. You got to pay the fees, and there's a lot to it, and they don't want to be giving an additional punishment over and above for the same conduct, over and above what has already been ordered by way of a sentence, right?
That's usually the original deal. Everybody try, and again, but what the judges are saying in that circumstances, we made a deal, you broke our deal first. So they can do it. But you see a lot of sympathy on both sides, and the goal of the courts is to get everybody made whole. And I think if the judges can get that money ordered back, but you brought up a great point with Judge Kilmartin, that they just don't have the resources to be a collections agency when they do have a division in the civil nature. But I think I think what I learned out of this was never ignore the civil remedies. So if there's an issue out there, you always have to protect your civil remedy as well as your criminal, because you've seen some judges won't order restitution at all. They think that it is a civil matter, and a lot of times it isn't. Before I forget, I think one of the bigger points I run into is, you see the word subrogation, but a lot of times most of these losses are covered by insurance. There was an insurance company that covered it. Now it's the insurance company, not the victim, that's out the money. And I think that's never brought up or brought to the attention of the courts that it's really not the victim now that's out the money. They've been compensated, and sometimes that happens after restitution has been ordered. And you can always go in and move, if the proper paperwork was filed, to move to reduce or modify that restitution order. But restitution, back to what you have to know the ability to pay before you went into that agreement.
So I think it all deals with issues of fairness. I think you're bringing up a very good point as far as you're trying to make people whole, and you're trying to deal with the needs of the victim, but you're also looking at the abilities of the defendant, and that was really what the court was focusing on, with the idea of extending probation and whether that was fair to give that additional punishment.
I think that's what we all want the court, and the court wants us to see is fairness.
Sure.
Period.
Sure. Now, the court, I think, also focused on the amount of probation that can be established at the inception of the case, not just dealing with a probation violation later on, but when a sentence is being fashioned. First of all, that's the time to be dealing with restitution, correct? I
think so. And because once you say or agree to restitution, you've agreed to restitution. Now, you can have the hearing, But that's dangerous because you don't know what that number is. Now, at least this court, or the court, has said that at the same time to determine that number, the judge has to look at the ability to pay. That's where I think the split was, is they'd agree on a number, they never looked at the defendant's ability to pay.
Right.
It came in secondarily, and instead of saying, no, you don't have to pay the money, they went with the option, no, let's extend your probation for a couple years.
Yeah.
In certain cases, I saw up to 3 years probation extended.
Really?
Yeah, so a kid was on probation for 5 years on an original, about 18 months to 2 years, just to keep paying the money. But during that time, you know, you have an issue here, issue there, you're doing 2 weeks in the House of Correction. Coming back out, no, I'll pay the money now. Okay, we give you another chance, another 2 weeks, a couple months later, just, you know, and that would go on and on and on, and that frustrated the judges,
Sure.
and it frustrated us as well.
But I think the court also focused on at the inception of the sentencing. First of all, when you're sentenced to probation, you're sentenced for a period of months, 6 months, 18 months, 2 years. And I think the court also focused on fashioning an amount of restitution based on, and I think they focused on the monthly ability to pay, but not having that final determination based on the amount of months that they were sentenced to. So if a person can only pay, let's say, $200 a month or a week or whatever, they're not to look at the number of months that are going to be part of it in terms of fashioning the restitution figure, right?
See, I think at this point, depending on the number and what the month calculation is, because, you know, if you have a $30,000 restitution amount and reasonable, like you say, 18 months, they're not going to, you know, they're not going to break it up that month. I think they're going to actually, in that case, look at the defendant's ability to pay. How much maximum can they pay a month? Let's say it was $100 over the 18 months. They're going to have to say, look, all the victim's going to get is $1,800, and that's all we're going to order. And that's, I suppose they could always go for a review, but again, you're getting into civil remedies at that point. And I think if a court was to order the, you know, $100 a month for 18 months, and that would be $1,800 out of $30,000. The victim still has the right to go to a civil court and have a judgment for the remainder.
Now, as far as, excuse me 1 second, let me pull up what I need to pull up here. First of all, in these hearings, as far as establishing the inability to pay, whose burden is it to establish that a person doesn't have that ability?
That would be the defendant. It's their burden to prove that they don't have the ability to pay. And I believe that's a preponderance of the evidence, the same standard that would be on the other side to prove whether it's retail or how much the property is worth.
Okay, and let's talk about that issue of retail versus the economic loss in just a second. But what are some of the factors that the court considers in assessing a person's ability to pay?
Well, in this case specifically, Miss Henry did not have a house to live in. She had lost her job at Walmart, and this was all brought up at the second hearing as far as her ability to pay, but she had been fired from Walmart, obviously, because she stole from there and admitted to it. She had no car, she was living with friends, and that's what the facts that went to the court were. So they agreed she did not have an ability to pay. Other things, usually the biggest teller is if they, you know, when we have clients, if we were appointed to them and they were found indigent up front, that form that they fill out up front usually gives that information, and at least a basis to see how much they can pay, because that's a pretty in-depth form that they have to fill out even at the inception of the case if they have, you know, publicly assisted counsel. But it's probably, you know, about the same criteria as to, you know, you have to show all your bills. I think the court would look at if you had frivolous bills, because I've heard those arguments where, you know, a client said, I can't pay my $200 cable bill, and a judge really thought that you shouldn't have a $200 cable bill when you owe somebody else $25,000. So that's something you have to be careful of, the information that you put before a judge when you're asking for leniency on paying somebody back money that you stole.
Yeah, Yeah, definitely. All right, so let's deal with this retail loss versus economic loss issue that was kind of a secondary issue in the Henry case. What was it that the court was wrestling with?
Retail, so the court actually looked at another case which involved Target, and the best way to compare is that Miss Henry in the Henry case was taking products that were actually not being scanned, put into somebody's cart, and they were taking them. So they were, consumer goods
Theoretically
that were
friends,
being
yeah.
paid at retail price. In the Target case, which was mentioned in the Henry case, there was a lot of items that were either wholesale or were not going to be sold, and Target was looking for full value. And in fact, they were actually looking for about $44,000 in loss prevention cost, and there was a lot of money that Target tried to put in as restitution, which the court said no. And again, in fairness, they said you only owe what the victim can prove. But in the Henry case, they
So
did
there's
hold.
the burden is with the Commonwealth, that they have to prove what the actual losses are that are related to that crime.
Correct. And in the Henry case, they still upheld the retail value because they actually did. Walmart did prove that retail value is what they owed. So the $5,000 restitution they felt was on the money at retail value. It was just extending probation was not correct.
So I guess it's a retail value versus versus replacement cost, I guess, would be what people are typically looking at. But the idea with the retail value in the Walmart case was because that's what they typically would have been able to sell it for.
It was going out the door as a purchased item, so I think the courts felt that it was being bought, even though deceitfully it was being bought. So
they would have made that money, but for the criminal conduct of the individual. Well, Chris, I thank you for talking with us about this topic.
it's great to be on, Chris.
And it's good to have you as our president appearing on the show. Oh, thank you. And I want to thank you all for your attention here. And I'll warn you, as I do at the end of every show, don't listen to the facts that are being put here and use those in making decisions that are vital to you as far as legal issues, legal problems. Go to local counsel. If you have a set of facts, if you have something that you have issues with, go to legal counsel. Go to local counsel and talk with them about your particular case, because they have the expertise to bring to that particular set of facts. What we're talking about here is just very general information. But on behalf of Chris Reardon, I'm Chris Lilly, and I thank you. Good night.